The House of Representatives Committee on Finance today queried irregularities in the registration of subsidiary companies under the Nigerian Postal Service NIPOST. The question was posed by Committee Chairman James Abiodun Falake during an interactive meeting on the 2024 to 2026 Medium-Term Expenditures Framework FSP. The Ministry of Finance Incorporated, MOFI, and other agencies appeared before the committee. Speaking during the session, Falake noted that documents before the committee showed that two subsidiary companies under NIPOST were registered under individual names as shareholders instead of the federal government. Wondering why that was so since NIPOST is a federal government asset, responding, the Chief Executive Officer of the MOFI, Dr. Armstrong Takang, admitted there were irregularities within the system and that he needed the support of the committee to address them. On the issues of 10 billion naira reportedly approved and withdrawn for processing the NIPOST subsidiary companies, Takang said the Bureau of Public Enterprises, BPE, will be in the best position to answer that.
As it is by law, they are the owner of this company, and they are the owner of all assets of NIPOST by law. Are you lawyers? That's what I understand. I also have another one, which NIPOST Logistics or something like that, also registered in personal names. So I want to know from you, did you give permission to CAC to register your assets in personal name, Nigerian assets? Because what I can see here is that even some of them, they were working as civil servants when this was registered. Well, some of them, they were civil servants, and some have retired. But as it is by law, they are the owners of NIPOST Properties and NIPOST Transport Limited. Can you please confirm what's responsible for this? And if you want to create a subsidiary, should the subsidiary come in personal names of individuals not known to, who never made contributions to the assets?
The question you raised is precisely why I did say earlier on in my remarks that there is an opportunity for this committee to really partner with us to regularize a lot of the irregularities that exist and persist in our system. That is just one example. There are many other examples where such anomalies exist and have persisted for many years. The simple answer to your question, Honorable Chairman, is that the answer is no. When you register an entity, especially a federal government-owned entity, the shareholder must be MOFI. As dated as the MOFI Act is, the very fundamental basis for that act talked about easements and rights. And so anything that federal government owns your shares in, it should have been registered under MOFI.